powered by International Committee of the Red Cross.
Cyberspace is the new frontier of conflict and brings with it its own challenges and dangers. The rationale underpinning the laws of war and its cardinal principles is to reduce the suffering of civilians in an armed conflict. As our lives become increasingly online, this suffering must also be prevented in the digital and analog world. For instance, distribution networks for food, water, energy, as well as healthcare, transportation, and businesses increasingly rely on information technology for their operations. Cyber operations then pose unique challenges for the law of armed conflict, as unlike nautical, aerial, and terrestrial attacks, they occur both in the physical and the systematic world. The laws of war subsequently must be applied in a way which allows for an evolutive and expansive interpretation, taking into account the colossal way in which our lives have changed through the advent of information technology. Any regime of law which cannot adapt to suit this new reality risks becoming irrelevant in the 21st century. So for this episode of Legally Speaking, I'm your host, Ayesha Malik, and today we're focusing on cyber operations and the laws of war. And to talk to us a little bit more, we have with us Dr. Tilman Rodenhäuser, who is a thematic legal advisor at the International Committee of the Red Cross's headquarters in Geneva. Thank you so much for joining us.
Thank you for having me.
So I wanted to start off by asking a very basic question for listeners who are new to the topic of cyber operations in war. How do the laws of war actually apply to cyber operations during an armed conflict?
I think what is very important to understand is that in most armed conflicts that we see today, in particular between states, cyber operations are part of warfare. And where at the Red Cross we are particularly worried about is cyber operations that disrupt the provision of essential services to populations. Think about electricity, water, banking, civilian companies. And here the bedrock rule of international humanitarian law is the principle of distinction. And that requires that all attacks, be they kinetic or cyber attacks, must only be directed against military objectives and must not be targeted against civilians. And that essential rule, that applies to cyber operations. There's no reasons why it would not. And similarly, basic principles such as proportionality in military operations and the obligation to take precautions, these fundamental principles, they apply in the same way to cyber operations as they apply to any other traditional warfare.
And when it comes to the cardinal principles of the rules of war and how they apply to cyber operations, when does a cyber operation qualify as an attack to which we could see the principles of distinction, proportionality, and precaution applying?
This is an excellent legal question. Actually, experts and states have different views on that. But think about it practically. Most cyber operations that we see today, they disrupt the functionality of computers or computer systems that make electricity stop working, but the electricity plant is physically unharmed. Or it disrupts water supply, but the water treatment facility still looks the same. So the damage that we see in this ICT space or caused through cyber operations is different from traditional warfare. And so here some of the experts differ. There's one group of states and experts that say a cyber operation is only regulated by these principles that you mentioned, distinction, proportionality, and precautions, if it causes physical damage. And then there's another group of states, I would count Pakistan in there, but also experts like the International Red Cross that say also the disruption of functionality of an object counts as damage. Today, if my computer or the network we're using stops working, it doesn't matter if it's physically destroyed or digitally destroyed. It still doesn't provide the service that it was meant to give us.
Yeah, and following on from that, another controversial area in the discourse around cyber operations. So would you deem civilian data or military data in and of itself to be an object to which we give the protections of civilian data, or which can be then targetable as a military object?
This is one of the other really important questions in today's legal discussions among governments on cyber operations in armed conflict. If we look at the laws of war, they state that civilian objects must not be targeted. And so government and experts have taken different views on whether data is protected similar to an object. If we consider how incredibly reliant our societies, us, but also medical facilities and local administrations are, how dependent we are on data, its availability, its integrity, to say that such data would not be protected similar to civilian objects would leave a huge range of issues unprotected under the laws of war. So this is really a significant question, and one where the ICRC is urging states to take positions that actually protect civilian space, to protect civilian populations against the effects of digitalizing warfare.
Yeah, and one of the very interesting aspects of this was a recent paper that you also wrote on the notion of propaganda. And I think we are seeing so many propaganda, information and disinformation campaigns, and we also saw Israel recently take out a state TV in Iran, and they used as rationale for that attack it was that it was a command and control center. But when can propaganda information campaigns violate the laws of war? Because as you know in the article, usually it's like most propaganda is something that both sides in an armed conflict will engage in, and the laws of war doesn't have that much to say about it. So when do propaganda information campaigns violate the laws of war?
Again, let's take it down to the reality that we see in armed conflict. Just as for you and I, the connectivity and the ability to submit, to find information online and to connect with family is incredibly important. And so especially for people affected by conflict who might flee from their homes, who lose contact to relatives, they need connectivity, and they also need online social media or messaging to find their loved ones. But at the same time, as you described, we also see digital technology, digital communication being used for military purposes. What we are really worried about is the incitement of violence through online tools. We see incitement of attacks against hospitals, incitement of attacks against civilians, against civilian infrastructure. This is really worrying. And this is prohibited by international humanitarian law. So propaganda that encourages on-site violence is unlawful, and that's confirmed by the International Court of Justice. Another point which we really worry about is the protection of detainees. Detainees are in a particular vulnerable situation. Their lives are in the hand of their captors. But often we see armed groups, but also states publishing pictures of detainees, publishing videos of detainees, often in very inhumane circumstances. And that again is prohibited by the laws of war. The prisoners of war must not be exposed to public curiosity, and their dignity must be respected. And so showing them in inhumane circumstances is certainly prohibited, and just exposing them online and publishing this propaganda is unlawful under the laws of war.
Yeah, and that's been a very interesting question that's come up in the Indian subcontinent in 2019, especially because we captured an Indian prisoner of war who was then put online, and images and videos of him were shared, even if there were benign questions like, how are you enjoying the tea? How are you enjoying what's happening in captivity? It's not something that, in exposing them to public curiosity, it could be for a negative reason, it could be for a positive reason, but I think it is still a violation of Article 13 of the Third Geneva Convention. They're in the context of giving these effective warnings and effective precautions in armed conflicts. So knowing that to receive an effective warning, you might, if it's given by QR code, you might need access to the internet. And we've seen this a lot in the context of the Gaza Strip, where Israel keeps on giving warnings and asking residents to leave, but we don't know how many of them have access to the internet to avail those warnings, or if they have the capacity or the ability to actually move. And a lot has been made over the fact that the warnings in themselves and where they're asking them to locate to might be faulty. But to what extent do we see that as a violation of the principle of precaution, in that effective warnings must be given, and to have them you must have internet? How does that factor into how state parties should be interacting with the principle of precaution?
I think just now you really pointed to the important aspects. Warnings need to be feasible warnings, and they must be effective. If you think today that several state armed forces, or also armed groups, they publish warnings online. And if the recipient population does not have access to the internet and cannot access these warnings, then these warnings are not effective, and they cannot reach and have the effect that they're even meant to have. So if an armed force first takes out the internet, but then publishes warnings that effectively can't reach the population because they no longer have access to connectivity or to online resources, then such a warning is essentially deprived of its meaning and can no longer be considered effective.
And when it comes to just approaching the entire question of cyber operations and armed conflict, we know that in 1949, when the Geneva Conventions were drafted and they were published, we still had armies facing across each other on a battlefield. Even in 1977, when we had updates in the form of the additional protocols, again, we didn't have the internet as we have it today. So to what extent do you think that we need a new rules of war which can apply to cyber operations, a dedicated cyber law of armed conflict, or do you think the existing laws of war are sufficient if they're interpreted correctly?
You pointed to the fact that today, on the 12th of August, the Geneva Conventions are 76 years old. And we need to understand, at the time they were drafted, not by some humanitarians, they were drafted by state militaries. And they were drafted in a way for future armed conflicts. You can't regulate the past, so necessarily they were meant to apply to the future. And that's confirmed by the International Court of Justice that said that these same rules apply to all means and methods of warfare, including those of the future. We see technological progress every day. We see new forms of drones, we see new forms of autonomy, we see new forms of cyber operations. We can't have new rules for each of these technologies, but rather the rules that exist are designed in a way that they can also apply to those new technologies. But let me give you one example where we believe that states actually have to interpret the rule in a protective way. They have to interpret the existing law in a protective way, because otherwise it risks losing some purpose. Today, we so much rely on digital data. And digital data, as we discussed before, may or may not be protected like a civilian object under the existing rules of the laws of war. If states now were to agree that data is not protected under the laws of war and data can just be damaged or destroyed with impunity, then we would see a real protection gap, and potentially the Red Cross together with states would call for new rules. But if the current rules are interpreted in a way that reflect the digitalizing nature of society and the challenges that we collectively face, then probably the existing rules are strong enough to keep us safe.
So today we also see an unprecedented number of hackers who are partaking in war, in an armed conflict, be it on a side of either of the state parties. And so what do the laws of war really have to say about that in terms of these individual hackers?
You're raising a really important point here, because at the moment, whenever we see an international armed conflict erupting between two or more states, we see immediately civilian hackers, are often referred to as hacktivists, taking part in the armed conflict, conducting their operations usually against one state in support of the other. What very much worries us is that these hackers operate often in ignorance of the existing laws of war, often attacking civilian targets, going after pharmacies, after public transport, banking, or simply companies and local administrations. So violating some of the most fundamental rules of international humanitarian law. What's very important here is for them to understand that they too have to comply with the existing rules. And the second point on that is that states are responsible for ensuring respect, including by these hackers. None of these hackers sits in cyberspace. They all sit on the territory of a country. And all countries have committed to ensure respect for humanitarian law, to make the rules of humanitarian law known to their civilian populations, and to suppress violations of the law. And these basic principles, all enshrined in the Geneva Convention, they also apply in the ICT environment to cyber operations. And so it is on states to stop these hacker groups from attacking civilian populations. Thank you very much.
Thank you so much. Thanks. Bye.
Thanks for inviting me. Ciao.
Yeah, thanks. We hope you enjoyed this episode of Legally Speaking on the cyber operations and the law of armed conflict and how they can interact and how the laws of war still continue to apply to cyber operations. Thank you so much for tuning in, and join us for our next episode next week.
Powered by International Committee of the Red Cross.